Hey, Kevin.
Hello, Rebecca.
I can't believe we're doing this right now.
Just checking my watch here.
I know. I was working.
More Readathon.
Yes, many more Readathon things. It is Monday, August 26th. And huge news today in the Karen Read case. Mm-hmm. Before I tell you that huge news, there's another thing I want to tell you about. And I wouldn't tell you this except Turtle Boy Aidan Carney has a history of being right about things, and he has a piece of reporting that I want to share with you. All
right.
Breaking news, Aidan Carney is reporting, the Commonwealth is not planning on bringing Trooper Paul back as their crash reconstruction expert.
No kidding.
In the next Karen Read trial, they are attempting to shop around for an independent paid expert who will offer an alternative theory for how John O'Keefe got his injuries, similarly for how they shopped around for a Google expert when they needed to explain away Jen McCabe's incriminating 227 search, and they came up with some guy from Alberta trying to promote his app. Sources tell me if they don't call Trooper Paul, then the defense will.
Yeah.
He was that bad.
He was that bad, absolutely.
Yeah, so we'll see. That interesting little piece of Turtle Boy scoop there. I call it a scoop, and I'm only repeating it unverified because in my experience, Turtle Boy's scoops have a habit of bearing out. There have been other scoops that I've seen on Twitter in the last couple of days that I would not repeat because I don't think they will bear out, but I have a feeling that one will because of patterns of his scoops being true. That being said, I can't say that for sure. All right, another huge piece of news in the case today. This is 100% true. The O'Keefe family, Paul O'Keefe, John O'Keefe's brother, has filed a lawsuit suing the Waterfall Bar, C.F. McCarthy's, and Karen Read. They're claiming that the two bars knowingly overserved her and that she caused John O'Keefe's death. And they are claiming that the defense that Karen Read put on caused them emotional distress. So basically, they put up the $50,000 amount, which is apparently the threshold amount for harm. I asked this question on Twitter. I'm like, why only $50,000? I thought that seemed low. Susan Simpson responded to my tweet and said, yes. And said basically that was a threshold amount. If you filed that, if you filed it higher than that, it would go to Superior Court. So basically that's a threshold amount and a jury would decide the harm damages above that.
Gotcha.
So that's why it's not for more. But there is a lot of conversation, as you can probably imagine, about this lawsuit going on. And a couple of lawyers have weighed in. And a lawyer who is an expert on this in Massachusetts weighed in. And would you like to hear what she had to say?
I'd love to hear what she has to say.
All right. Her name is Andrea Burkhart. And here's what she had to say. Number one, Karen almost certainly has insurance that will cover or contribute to the cost of her defense. This could help her significantly in preparing for retrial in the criminal case. I'm also thinking, by the way, that her insurance company could also try, be a lawyer in the case. We're talking about her auto insurance company. Right. Because when you allegedly kill somebody with your car, it's your auto insurance company that usually takes on that claim.
Yeah.
Or if you have umbrella insurance of some kind, it's that insurance company that takes on your claim. Okay.
Yeah.
Number two, this person says, Karen could implead the Alberts as third parties if she wants to try to prove they inflicted the injuries claimed, not her. And that would open big doors in discovery that were not available in the criminal process.
I wonder such as what?
3, the civil suit is now impeachable evidence of Paul O'Keefe's bias in the criminal trial, because he stands to benefit financially from Karen being convicted.
Yes.
So that's a whole other thing.
So is that kind of an oopsie, you think? Well, I got to think that the prosecution isn't pleased with this.
Well, you know who I would think? I mean, I guess there was a statute of limitations or a time frame under which he had to file this. Apparently, it was sometime in 2025. I wonder if there was another clock is ticking situation where there were pressures, I think, to filing this perhaps before the state decided to drop charges, filing this. I wonder if maybe there's a sense that if this were filed and if she settled, that would be some sort of public proof of guilt that might influence something else, because it wouldn't be her settling, right? It would probably be an insurance company settling.
Yeah.
Right? So that would sort of be seen as some public proof of guilt.
Yeah, because if you're also suing these restaurants.
The bars, yes.
Yeah, which I guess is like not uncommon in a drunk driving civil case.
Right.
Where
we had that in New Hampshire a few years ago.
Yeah. Yeah. And so, I guess I would say that probably more often than not that the lawyers for the insurance companies for the bars will try to find a number. So you're right. They are probably, unless they are really pro Karen Read, right? I think that their normal course of business would be to negotiate to the lowest acceptable number and make a payout, so not to proceed to trial. But I guess you could say if the restaurants feel strongly that Karen Read did not do that, if it's proven that someone else killed John O'Keefe, then the bars are not responsible for overserving Karen Read.
I have a question though.
Yeah.
All right. So there was a cop here in New Hampshire that was killed by a drunk driver who was overserved by a bar at a Chinese restaurant. Chinese restaurant, by the way, where we often get takeout. Remember that case?
I do, kid. Yeah.
All right. So he was a brand new cop. It was like his first week on the job. It was a really well-known case. It was a small town cop in our town, actually, in New Hampshire. And they ended up being sued. It was a huge case. They know for sure that guy was drinking at their bar before he hit this cop who was on a motorcycle and killed him. There is no evidence that Karen Read killed John O'Keefe with her car. There's no video. She's not admitting it. She was arrested for it, but she hasn't been convicted of it. And there are expert witnesses who say she didn't. So my question is this. If the bars are also insured, right?
Yeah.
Insurance companies don't like to pay claims.
Right.
We have a friend who's an attorney for an insurance company who does this exact kind of work. He fights claims. He does accident claims. He does exactly these kinds of claims. He does civil claims. He does all these claims. He has literally told me his whole job is payment avoidance. It's his whole freaking job. And they would rather pay more for a trial than it would cost to pay the claim in many instances, because payment of a claim sometimes implies something that another claimant would then try to get money for.
So it's a calculation.
Very often it's a calculation.
Based on, not based on the facts of the case at all.
Sometimes it is and sometimes it isn't, right? So sometimes it's like they look at it and they're like, okay, settle. But sometimes it's like, we will fight this even if it costs more, because we don't want to set a precedent for another claim here. So keep in mind that you have other people at this bar who were also drinking, that the bar also served that night, who were also driving. All right. So this is what comes to mind for me. There are other potential people here who could have killed John O'Keefe, right? That were also being served at these bars.
Okay.
So if they don't fight this.
Who's they? If the bars do not fight this, yeah.
What happens if it turns out someone else, it's proven later that someone else killed John, and they get sued again? Like they could be sued like for someone else. Like they could be sued and sued.
Yeah,
you know what I mean?
The caveat always is that you can sue anybody for anything.
Yeah.
It doesn't necessarily mean that you're going to prevail, but I mean, this is not uncommon at all.
Yeah, I know.
That oftentimes that the family of a victim will sue the driver if, they're involved in a car crash or a pedestrian accident, which is what this is. Certainly if that driver is charged with vehicular homicide or a similar crime, right?
Right.
Because it's a civil, so
it's typically when the facts of the accident are known, though.
Well, they're going to argue, the O'Keefes argue, the facts of the case are known.
Yeah.
We can quibble about that's not even a quibble, but we can argue what the facts are. But this isn't a mystery on paper to these lawyers.
Right.
Right? I mean, the same set of facts that were used against Karen Read at her criminal trial can be used against her at her civil trial. Right. I mean, in broad strokes, yes.
Or there'll be depositions, though. And Karen Read's defense here and the bar's attorneys can call all the same people.
Yes.
They can call
Yes.
the Alberts. They can call the McCabe's.
Yes.
They can call the experts.
Right.
And there will be no objections.
Mhm.
There will be no ask it differently. There will be no you can't bring this up. And they can catch them committing perjury and depositions. They can ask them about previous proceedings. They can ask them about the federal investigation. They can ask them anything they want in depositions, right?
Yeah.
So-
yeah, but they're not always compelled to answer.
Right.
In a civil thing, the lawyer can object to the question. Although I think probably in the civil, I'm trying to remember between civil and criminal, like whether or not like you still have to answer the question, although you may object to it. Yeah, I mean all that stuff that comes out in any case is something that can be used against you in a criminal proceeding. And this is not uncommon where civil and criminal proceedings happen in parallel.
It's not uncommon at all. Happened in the O.J. Simpson case. It's happened in lots of cases.
The civil case happened long after the criminal case, right?
But also he wasn't proven guilty in that case, and then he
also wasn't proven guilty in that case, and they still prevailed in the civil trial. I think that you brought up the restaurants, like they certainly, if they can prove, or if they're successful in the argument that Karen Read didn't kill John O'Keefe, then they're not responsible at all as far as overserving her, because they're going to. The theory of the civil case is that you overserved, and had you not overserved, the subsequent events would not have occurred. And so those subsequent events are irrelevant because, if you say the cause of death is not Karen Read and not drunk driving, not the car, or even if even if she's convicted at a criminal proceeding. Although that's strong evidence against her, that could be used against her in a civil trial. I mean, they could still convince the civil jury that she didn't do it, right, and not win there. So that's definitely what the restaurants are hoping for. If, however, they, because usually what they'll do in this case when they get this kind of suit is like one of the things they'll go to is that we didn't overserve or knowingly overserve. I know in one of the cases, one of the bars, Karen Read ordered a soda, and she secretly put vodka in or something like that. Allegedly. Okay. Well, I mean, they would argue that. So we only served her 2 drinks. We didn't know she was also, she hid that from us. Right. That's exculpatory civil evidence. I'm not using the right term here, but those are the things. So their first argument would probably be, I'm sure they're going to ask for a continuance because of the civil, the criminal jeopardy that the defendant is in, right, or that the respondent in the civil case is in, right. So Karen Read, Aidan Carney says he has been a defendant in civil cases before, and according to him, Karen Read may be able to stay her case because she has Fifth Amendment rights as a criminal defendant right now. Yeah. The bars will not, and they don't have the same kind of thing. It also makes me wonder if she doesn't stay her case, she'll be able to plead the Fifth in depositions because she's a defendant in a civil case, in a criminal case, right? Yes, but civil juries can take that into account. They can take a negative inference to her unwillingness to in a civil case, absolutely. And if she were acquitted, then she would have no First Amendment right to not answer in a civil trial. So she would have to answer any of those questions if she were no longer in legal peril. Now, civil testimony has been used in criminal cases before, right? Yeah, sure. So if these civil proceedings, if there are depositions taken of Alberts, McCabe's, etc., in this proceeding, unless they are kept out of a criminal trial, which, I think Bev Canoni has shown that she does like keeping things out of trials. They could be used in a trial. So there's yet another proceeding that could be asked about or pointed to. And another opaquely referenced other proceeding. Did you not in another proceeding testify that? Did you not in a deposition say that? Yeah. Because they've shown them transcripts of depositions before in the trial. Yeah. So this is an interesting development. It's certainly worth watching, especially with 3 separate defendants now, here who are going to have ostensibly 3 separate legal strategies, 3 separate opportunities to do 3 separate investigations,
ARCA investigation could come into play again. The ARCA investigation is the most compelling evidence to prove that she did not hit him with her car.
Yeah.
And now all three of these entities, especially the insurance companies for the restaurants, will no doubt bring in those federal investigators into their cases. Don't you think?
Yeah. Yeah. And in addition to sort of Karen Read putting herself in some potential jeopardy by answering another lawyer's questions, maybe questions that she couldn't, would not be compelled to answer at trial. But as you say, like, so do all the Alberts and McCabe's. And the civil lawyers can go after them in ways that a criminal attorney could not during deposition. So, yeah, I mean, as far as fact-finding missions, which often what, depositions are, there is a lot on the line for everybody.
Yeah. So, interesting thing that I've been thinking about today. A lot of the anti-Karen Read people are like, yes, she's going to pay. This is probably why she sold her house, whatever. A lot of people in the legal community and a lot of people, of course, on the pro-Karen Read side who are saying this more vehemently is that O'Keefe, with his timing, has potentially really fucked over the Alberts and McCabe's here.
And explain why.
Well, they are going to be deposed.
Yeah.
And they do not
potentially before the second criminal trial.
Potentially before the second criminal trial. Also, even if it's after, like, this is not something they want.
No.
They do not want to be involved. I mean...
Right. Because here's what's going to happen. At the criminal trial, Karen Read will not testify.
Right.
But again, if this times out this way, all of those, the McCabe's and the Alberts, well, I'll just call them the McAlberts again, all the McAlberts will have been questioned. This will be their third time.
Yep.
Right? So once on the stand, once during civil deposition, again. So there's going to be a lot to compare and contrast and use to impeach each of those witnesses.
Right.
And, they have some advantage because they will have been asked questions and they will have had time to prepare. And as we saw from the jurors' impression, like with Colin Albert, like, he seemed to be really good on the questions that he was prepared for, and what he wasn't prepared for, he kind of fucked up.
No, they said he was elusive on
the elusive. Okay.
Questions he was prepared for.
All right, but now he can be elusive on so much more because he knows what's,
extra elusive.
He's had a lot of time to figure out, what the real explanation for the knuckles on his right hand.
Yeah, how could I be elusive more effectively?
Yeah.
But elusive is bad, right? Elusive is bad.
It can be. It certainly can be. But there's a lot of I do not recalls coming from those folks.
Yeah. Yeah. Or show me where I said that and then I can confirm or deny it.
Yeah.
I'll tell you, I would encourage folks, if they're curious, to watch videos of depositions. Depositions are very different than on-stand testimony. Like, lawyers can ask people basically whatever they want. Mm-hmm. And usually that person is with a lawyer who can tell them, what to do or what not to do. But, like, those things can go on for hours and hours. People can get very uncomfortable.
So can cross-examination in a criminal trial.
Exactly. Yeah. But it's definitely like they're videotaped. They're more candid. There is no judge there saying what you can or can't ask. There are no objections. There's no...
Well, no, you can object, but that doesn't mean they're enforceable.
No, that's what I mean. Yeah. I mean, there's no, like, strike it. I mean, it's on videotape.
Ask it a different way.
Exactly. There's none of that kind of stuff.
Move along.
Anyway, so we'll see what happens. It's just I just can't help but wonder what the McAlberts are thinking about on a day like today.
Yeah. Certainly the civil case will not be heard in open court before the criminal trial, but maybe some of the proceedings like the depositions would occur before January. The clock's ticking. Yeah.
It's not going to, you have said
That's
yourself,
not a long way
it's not going to be January with these appeals in this decision.
This is true. This
right?
is true. Yeah.
Because Judge Cannoni, put her decision out. There's going to be an appeal of her decision. Mm-hmm. It's going to take a while now, right?
Yeah.
How can it be January? It's just a couple months away.
Right. But presuming that they don't appeal, who knows? Who knows?
Who knows? All right, Kevin, here we have been in another readathon. Do you feel deposed?
I feel like I've been thoroughly deposed.
All right, well then let's wrap it there. Talk to you soon.
in crime media.